Hello again, this is Tim back here, and for this lesson I am going to discuss the Sixth Amendment. This again is one that a lot of you are probably familiar with, especially if you watch um, uh, police procedural shows like Law and Order or Blue Bloods or anything like that. Um, I'm gonna start by reading it again. This was a little bit lengthier, not unlike the Fifth Amendment one, so I put it a bit on the bigger board. So bear with me as I try to read this for you here. In all criminal cases, the accused shall enjoy the right to a speedy and public trial by impartial jury of the state and district wherein the crime shall have been committed, in which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So again, a lot going on there in terms of the language, but basically, in layman's terms, you have the right to a speedy trial if you're accused of a crime. You have the right to a trial by a jury, though you can deny, you can turn down that right and have a trial by a judge. You have the right to be informed of the nature, basically the accusation against you. What are you being charged with? You have the right to see the witnesses, the people who are accusing you of things. You have the right to get your own witnesses, and of course you have the right to counsel. So some of this kind of gets enveloped into the Miranda rights, which I mentioned in the Fifth Amendment. You have the right to remain silent, the right to attorney. If you can't afford an attorney, the court will appoint one for you, etc., etc. That kind of goes into play here. So again, I'm going to take this piece by piece. So a lot of this goes again to ensuring a fair and legitimate trial. Back in the day of the Founding Fathers, again, there wasn't really an organized police force. That's a very modern thing. There were local sheriffs, but oftentimes citizens served as constables or night watchmen. So there wasn't like a professionalized police force like we have today. Oftentimes, criminal cases were brought by victims, not prosecutors. A lot of times, the accused and the accuser did not have witnesses. So they kind of broke down into shouting matches and accusations, and there were, of course, witnesses on either side. But it wasn't nearly the organized process that we have today. So a big thing with that was the juries. There were 12 ordinary individuals. They were essential to kind of cut through all the white noise. They were also essential because they provided kind of a check on the government. So the government couldn't just mete out punishment as it saw fit. It had to go through the civilian process. The people were able to kind of mitigate the power of the government. So that is kind of the history behind juries. Nowadays, we have professional police forces. We have people whose jobs are to be police officers. We have prosecutors. We have defense lawyers. We have public defenders. And as a result, we have a lot longer trials. Back in the day of the founding, a lot of times trials only lasted minutes or hours. Now they could last potentially years, especially in bigger cases. As a result, oftentimes you see more plea bargains. The prosecutor and the defense attorney coming to some sort of agreement, therefore rendering a jury unnecessary. But again, that's just because there's so much more of an organized system than we had back in the 1800s or the 1800s. One of the big things was the rights for criminals to have a court-appointed attorney. So in the Supreme Court case Gideon versus Wainwright in 1963, the Supreme Court ruled that if someone couldn't afford a lawyer, they were supposed to be given one at the court's expense, and that lawyer was supposed to provide adequate defense. Now, obviously, what constitutes adequate defense is kind of a broad interpretation, but at the same time, it's still required they have one. Again, this kind of goes along with those Miranda rights that I talked about in the Fifth Amendment one. And also in the same vein of being kind of a broad interpretation, the idea of a speedy trial. Oftentimes, courts approach that very leniently. You see some cases lasting years, some trials lasting years. And part of that is because if there is some sort of issue with a speedy trial, then they have to dismiss the whole prosecution and a whole new prosecution. So obviously that's not something you want to go through because it just makes you start the whole process over again. So that's why, again, they are a little bit lenient with the speedy trial part of this. Public access, however, is much more strictly looked at. Usually, the public is able to sit down and watch these cases. But in case of where there's a possible danger or some nature, the courts could decide to not have anybody in there. That is a big possibility. So, that's an idea too. Defendants being able to subpoena their own witnesses, that is a big one. They can force people to testify. Okay, you can force a witness to testify in your behalf. Okay. Defendants can also testify in their own defense. I know a lot of lawyers don't oftentimes encourage that, but it is an option. These witnesses have to testify under oath. You may have seen that again in law, criminal procedure movies or shows. Do you swear to tell the truth, the whole truth, nothing but the truth, while having your hand on a Bible, that sort of deal. There are exceptions for children where some of this testimony may be made kind of traumatizing. Maybe traumatizing to them. I found the word there. But generally speaking, if you're subpoenaed, you must testify under oath, and you must make yourself available to be cross-examined. So the opposing attorney has also be able to have the option to question you. The witnesses must be brought to the court. So if someone accuses somebody of something, they have to appear in court. The police can't just use someone saying, hey, they did that, and arrest somebody, but not have that person, the accusing person, be in court. They can't use that. So any accuser must appear in court in front of the person they're accusing. And defendants also have the right to be in the courtroom as well. They have the right to defend themselves as well. That being said, a defendant can forfeit that right if they are not behaving in accordance with the rules that the judge lays down. So if the defendant is behaving badly, the judge could rule him could kick him out. But generally speaking, the defendant has the option to testify for himself, to defend himself, and also be present in his own trial. So that takes up a big chunk of that area here. In terms of the jury, again, the criminal cases must be, if there is a criminal case where the possible penalty is 6 months imprisonment or more, you need to have a jury. So a jury is almost always 12 jurors. There are certain places where you only need 6, but most of the time you need 12 jurors. And pretty much every single state requires that these verdicts, the juries, whether or not they say they're guilty or innocent, they have to be unanimous. There are a few states, such as Louisiana, Oregon, that have accepted 11 yes versus 1 no, or 10 yes versus 2 no. Supreme Court did not make this a requirement for juries, but generally speaking, most states require 12, all 12 of the jurors to say yes to a verdict, whether or not be finding someone innocent or finding someone guilty. Now, this leaves a lot of room for the juries in terms of what kind of powers they have. They really can do, I don't say do what they want, but they can find someone innocent or guilty regardless of the strength of the prosecution's case. It's really, again, the jury's responsibility to determine whether or not this person is guilty, or whether they're guilty, or whether or not there is some sort of reason why they might not be guilty. You might have heard the term probable cause. So the jury has a lot of power in this case. Now, this is not to be mistaken with the grand jury. So in the Fifth Amendment, they talk about a grand jury. Again, a grand jury is when it's almost like the jury before the case itself. The prosecution brings in the 12 individuals, he lays down his case, and those individuals determine whether or not the case can move forward. That's a grand jury, and that's again used almost exclusively in federal cases. Some states do use it as well. This jury is for the actual case itself. So this jury actually sits through the trials, listens to the evidence, and then determines whether or not someone is guilty or not. So don't get this jury mixed up with a grand jury. They're two very different things. So yeah, that's really it for this one. Again, it's a very important one for today's society and trials and whatnot. Despite the length, there's really not a whole lot that goes into it. The old-timey language kind of makes it a little bit longer than it needs to be. But regardless, I hope this helped out in your understanding of the Sixth Amendment, and I will see you in the next lesson.